Welcome to Opinion TV. Today, the opinion is that motions to reopen should be favored, that granting motions to reopen should be favored and rather than disfavored. The thing about motions to reopen is that there are two cases, U.S. Supreme Court cases, that get cited even today. INS versus Abudu and INS versus Dougherty, and they get cited even today for the proposition that motions to reopen are disfavored because every delay, they're used to delay, and every delay works to the benefit of the foreign national, and they're a waste of judicial resources. Well, INS versus Abudu was decided in 1988, and INS versus Dougherty was decided in 1992. But in 1996, Congress, around 1996, Congress changed the rules so that people could not do, foreign nationals could not file motions to reopen. They put numerical limitations and time limitations on motions to reopen. And so motions to reopen, maybe there had been an abuse by foreign nationals, respondents, and their attorneys. But that if there had been abuse, that abuse was put to an end. Now, U.S. immigration continues to cite to INS versus Dougherty and INS versus Abudu for the proposition that for the same reasons that the U.S. Supreme Court mentioned before the rules changed, and so the U.S. Supreme Court really needs to review these cases, and since only one motion to reopen is allowed within a very short period of time from the decision of the immigration judge or from the decision of the Board of Immigration Appeals, U.S. Supreme Court really ought to review these decisions and modify them. Anyway, so all right, if the normative value, if the goal of limiting, of disfavoring motions to reopen is a waste of judicial resources, then I would suggest that favoring motions to reopen is actually results in a better use of judicial resources, and there's a reason for this. Who gets stuck with the burden of endless appeals? The Circuit Court of Appeals and the federal district courts. Those are the courts that are really facing the biggest burden they're being taxed the most, whose resources are being taxed the most by all these immigration appeals. Who is in the best position to effectively, efficiently, cheaply use government resources to review the merits of a motion to reopen if there's a chance of winning? I'm not talking about if there's no chance of winning a motion to reopen, but if there's a chance of winning a motion to reopen, immigration judges. They have they're set up to use the least amount of government resources to check out the merits of a motion to reopen. And since there's been such a huge limitation placed on motions to reopen, it makes a lot of sense to actually favor rather than disfavor motions to reopen from the U.S. Supreme Court's point of view, to limit the number of appeals that are brought by foreign nationals. I mean, even I can figure that one out.